Now, in establishing good faith, some of the documents that immigration will look for are joint documents. Joint documents are anything that shows that the couple shares financial responsibility, have commingled assets, and generally have intended to establish a life together. Now, what are these documents? Immigration will look for things like jointly filed tax returns, joint leases if the couple rents a place, a deed with both their names on if they own property, joint bank accounts, an insurance policy that lists the spouse as the beneficiary, medical insurance that lists the spouse as a beneficiary, utility bills with both their names on it, cell phone plans, cell phone family plans which have both their names on it. Anything that tends to show that the couple actually lives together and commingle financial assets and otherwise share responsibility and basically intend to establish a life together. Photos that tend to show the couple have spent a lot of time together, have spent time with each other's families or friends. Those are also acceptable pieces of evidence. Part of the process of filing a petition is after you file the petition, you'll get a receipt from immigration. The person will be fingerprinted and have to undergo background checks, and then they will go to an interview. And so at this interview is when you will present these joint documents if you haven't already included it with your petition. And an interviewing officer from CIS will examine the couple and ask them questions about the marriage. Now, they are allowed to ask questions really about anything about the marriage. They have broad discretion to ask questions about the courtship, about the proposal, about the wedding, about married life together, their daily routines, and about their marital residence. If the couple has been married for 2 years or more, then if they get their petition approved and apply for a green card, they get a permanent green card, which is good for 10 years. If they were married for less than 2 years, then they are given what's called a conditional green card or a temporary green card, which is only good for 2 years. 90 days before the expiration of the temporary green card, the couple has to petition jointly to immigration to have what's called the conditions removed, or basically convert the temporary green card to a permanent green card. What that involves is filing a different form, the I-751, but including all current bona fide joint documents, possibly submitting to an interview or not if the documents submitted were strong enough, but basically going through the whole process all over again. You have to prove to immigration that, yes, you're still living with your spouse and it is still a good marriage. The other thing to note about green cards is that the green cards are what expire in 10 years. A person's status as a lawful permanent resident doesn't expire unless the person has done something to violate the provisions of that status or to have that status revoked. If they decide to apply under the 3-year expedited track, it's almost like applying for the green card all over again. It's still establishing that the marriage is bona fide, that they are actually living together, and so all the joint documents that were required the first time around when they were applying for the green card will also be required for the naturalization interview. So sometimes it may just be easier, not because the marriage is not bona fide, but maybe just easier for an individual to wait until they've had their green card for 5 years. So it's just another 2 years, and then they can apply for naturalization on their own. So they don't have to submit all the joint documents. They don't have to answer questions about whether or not the marriage is bona fide. All they have to do is show that they have knowledge of U.S. government and civics and history and pass the English reading and writing test. What the immigration judge will look at is whether or not the respondent is a flight risk or poses a danger to the community. If he can show that he's neither a flight risk or a danger to the community, the immigration judge, at his or her discretion, can opt to reduce the bond or release the respondent on no bond. The lowest possible bond is $1,500. And some of the pieces of evidence that a respondent can submit to show that he's not a flight risk or a danger to the community is ties to the community. He has a lot of family here, and especially family that are green card holders or U.S. citizens. He can submit documentation and proof of that, copies of their green cards or naturalization certificates or U.S. passports, along with birth certificates to show relationship. He can show that he has property here. If he has been working, he can submit a job letter from his boss. He can submit pay stubs. He can show that he's filed taxes, so he's, a person of good moral character. Anything that will tend to show that the respondent has ties to the community is not likely going to leave all that behind and not appear at his next hearing.